Hey, welcome back, everybody. Good morning. It's Law and Legitimacy. And if you're listening, Dawn, I promise I won't use the word sociologist or sociology at all today, though that word will not pass my lips. I mean, we can talk about the sociology of knowledge, but I won't do it. We could talk about the sociological impact of how collective experiences shapes individual consciousness. I'm just not going to do it because yesterday, I think actually Dawn is still pissed at me because I was talking about the Mile Wide Club on Monday, and she said that she wanted to know if I would make such quote unquote lustful arguments in court. These aren't lustful. I mean, there's nothing wrong with aesthetic standards, okay? And when you go to see Michelangelo's David, what you're looking at is a well-sculpted human body. You don't want to see a guy who had trouble fitting into a porta potty. And when you're freaking on an airplane and somebody comes down to serve you coffee, you don't want to see her having to force her thighs down the aisle. There's nothing wrong with a little bit of gratuitous lust and desire. It makes the world go round. But I digress. So I won't say sociology at all. Dawn needs a safe space. I'm giving you a safe space here, dear. I won't trigger you. Let's talk about what's wrong with the world today. And good morning, Dawn. We need to get Dawn on as a guest. I gather she's a retired academic sociologist with a thing for pickleball. And I'm not going to ask. I mean, I could be offended as a male. She wants to play pickleball. I mean, what is she trying to say about what should be done to certain significant parts of yours and my anatomy? That it should be pickled, that she should be able to swat it around with abandon. I'm not going to talk about the sociological phenomena that is pickleball. I'm not going to do it. But let's talk. Let's pivot.
Dawn is the director of the Anti-Social Social Club. Welcome.
Oh man, Dawn. We love you, Dawn. Thank you for listening. Donald Trump, has he already been prosecuted? Is there a valid double jeopardy argument to be had against his prosecution for a criminal offense on January 6th. His lawyers have done a better job than I expected them to do, crafting legal challenges to the prosecution. You're laughing, Mike. Is that because my expectations were so low? I've been critical of the Trump prosecution defenses in general as lacking a sort of thematic unity, and I think that Trump has missed an opportunity to take his case to the American people in a more sophisticated way. But it may be that I'm asking for him to drive a Porsche when his preferred car is a Chrysler. He's got the horsepower he has. He's appealing for whatever reasons. And he can't be more than he is. I get that. But yet a series of motions have been filed, including a motion to dismiss the January 6th criminal prosecution on the grounds that Mr. Trump was impeached and acquitted of that impeachment charge.
So, Norm, may I interrupt you for just a moment, because I think we're going to get very technical here in a moment, and that's why I wanted you to talk about it. But I think we can concede at this point in the conversation that entertaining the idea that a double jeopardy defense, right, or a motion to dismiss that sounds in double jeopardy as the legal theory, is far from ideal under the circumstances if you're a criminal defendant in Donald Trump's position. Correct?
Well, I don't know what that means. I mean, look, my objective as a criminal defense lawyer is to get rid of the case, period. And I don't care.
Is that under the circumstances, we would prefer that this not have to be as artful, right? Is what I'm saying. You know what I mean? It's like that we are far removed from what we thought that this should even that a Trump legal team would have to engender in the pursuit of clearing his name. Right, that we are looking into constitutional doctrine that, by and large, I think we can agree that when it comes to the impeachment process from the Senate, because that is where this theory emanates from, right? This is a novel legal theory applying the standard of double jeopardy in a federal criminal context based on a failed impeachment proceeding through the Senate.
Yeah, but yes, it is, and so I guess what I hear you saying, Mike, is should Trump Trump be prosecuted in a J6 basis, in the J6 case at all? And the answer, in my view, is probably not, but he is. And so from the lawyer's perspective, his lawyer's perspective, the question becomes, how do you stop this prosecution in its tracks? And so a double jeopardy argument, it would challenge the subject matter jurisdiction of a court to hear this. And subject matter jurisdiction can be raised by any party at any time in the proceedings. It basically says the court lacks the power to hear this. And in Trump's lawyer's opinions, because he was tried in the Senate and acquitted, he cannot be placed twice. His life or limb cannot twice be placed in jeopardy by the federal government. And therefore, he cannot be tried by a jury, by the federal government before a jury for crimes. I would not have filed that motion. I think it's approaching frivolous, frankly, and I was surprised to see the New York Sun get behind it and gather support for it. And here's why. There are a number of ways to interpret the Constitution, including the double jeopardy clause. You can focus on the word, you can focus on the text, you can focus on the structure of the Constitution, you can focus on the history of legal doctrines that these terms have evoked and how they've been applied over time. And none of those methodologies support Trump. So with respect to the double jeopardy clause's language, not being twice placed in jeopardy for life or liberty, Donald Trump, no one ever sought the death penalty against Trump in the Senate. I mean, a political death penalty, yes, but I don't think that's what life meant in the Constitution. And second, liberty. Now, he has a liberty interest in remaining president, and there were procedures for the double jeopardy, there were procedures for the impeachment process to follow in the Senate and in the House, and those proceedings were followed. He was indicted, as it were, or charged by the House. The Senate tried him, and he was acquitted. His liberty interest in remaining president was evoked, but he didn't face incarceration. He faced loss of office, and I think there's a difference. So I don't.
So that is, I think that you're right in that yes, the consequence to him was removal from office. However, we know that a conviction in this context explicitly opens the pathway on constitutional grounds for further prosecution. Right.
So I don't know that it opens the door. I'm not sure it's relevant. I mean, had he been impeached, those findings from the Senate would not necessarily have been admissible in a criminal trial. It seems to me that a prosecution of him would still have had to be initiated by a grand jury. And maybe that information would be presented to a grand jury. Maybe it wouldn't. Maybe it would be improper if it were. I don't think we've seen this fact pattern yet as a matter of law in the United States. I simply don't think that the Senate was a trial, but it really wasn't a trial conducted by the rules of criminal procedure. The Senate is capable and does invent its own procedures. It's not bound by the rules of evidence. It's not bound by the rules of criminal procedure. It's not even bound by those rules of constitutional law that govern criminal procedures. This is a political process. It's a political act, and it's done for political reasons. So I don't think it has any precedential impact on a decision to prosecute him at all. And so it seems
they still have the power to subpoena witnesses, right?
Yeah, they do, but that comes from Congress.
I would bring that up because we talked about it before, right?
That comes from Congress's plenary power to conduct investigations, but it doesn't have the power to lock somebody up. It doesn't have the power to execute them. If the penalty calls for that. In fact, it doesn't even pursue. We don't have a federal common law of crimes. There's not even a particular statute that the president would be accused of violating in an impeachment proceeding. He's simply unfit for office because of a high crime or misdemeanor, and determining what those words mean are political questions. And so I don't, in terms of the text of the document, it just doesn't work. In terms of the structure of the document, I think criminal prosecution is different than an impeachment proceeding. Different procedures, different process, some overlap, as in the impeachment process. In terms of the history of the republic, there's nothing that suggests we've ever viewed things in this way. So I view the double jeopardy argument, frankly, as frivolous. And were I Judge Chetman, I wouldn't agonize to too much over my decision denying it. And if I were the United States government, I wouldn't worry too much about an appellate court saying that it is a violation of double jeopardy. The more serious argument, in my view, is the presidential immunity aspect of it. Whatever Trump did until the point that power was transferred at noon on January 20th, 2021, he did as chief executive officer of the United States. He was president of the United States, and he has political judgments to make, and he made decisions based on his assessment of politics. And we typically say that there is no subject matter jurisdiction over political questions for elected officials. And thus, we limit the court's power to get involved in judging those. Now, Jack Smith's response and the DOJ's response would be, yeah, he has the right to make political judgments, but he doesn't have the right to engage in criminal behavior. And so, seeking to committing fraud, for example, he's not immune from that. I'm not entirely sure. It's not as though Donald Trump sought to rob a bank. He took a position that the election was stolen. He took the position that there was undue influence brought to bear in various states on various electors in various ways. And I think he had a right to do that. Now, the prosecuting him for making bad judgments, I think is dangerous. I think Smith has a point. If Trump had walked out of the White House and murdered every third person that walked by for a 5-minute period, would he be immune from those murder charges? I doubt it. I don't know that anybody would make that case.
He's got to have a drone do that.
Yeah, but that's not what he did here. So as to the double jeopardy thing, I saw the New York Sun piece. I love the New York Sun. I think it's a refreshing voice in an otherwise dull and gray universe of mainstream media reporting. But I think they've swallowed some Kool-Aid here. And you heard it here second, third, or fourth, because I'm sure somebody else has said it before. This argument, the Trump double jeopardy argument, is dead on arrival.
Well, I worry, Norm. I worry two things here. Hans, just want to recognize the comment on Rumble before you even brought up the immunity piece of this. Hans said, I don't think it's a strict double jeopardy argument. It's immunity without first impeachment, which makes sense to me, right? That it's almost a way to embolden the presidential immunity argument, right? That we would even have to entertain the double jeopardy argument. I also think, as a downstream consequence to this, if the court were to find in Donald Trump's favor and dismiss the lawsuit entirely based on the double jeopardy argument, I feel like there's some pretty unwanted and unseemly political consequences downstream that we would see as a byproduct of politicians knowing that that those two things are linked, right? That
how so, Mike? I don't. To me, the argument is so fantastic. It's like asking me what would happen if Martians landed, in the infield during the 9th inning of a World Series game. It's just not going to happen.
I just think it incentivize more criminal behavior, because a failed impeachment process would then take away the ability for the American justice system to rectify and resolve wrongs after the fact, right? So I think that the judge here, Judge Chutkan, probably has an obligation to the entire country to dismiss the double jeopardy argument on that connection alone. I think the political consequences would be much far dire. But again, it's not as if we're not in dire circumstances right now. So maybe I'm throwing the baby out with the bathwater.
I don't know. I don't even think she needs to reach that issue. I just think, as a matter of simple constitutional interpretation, applying traditional methods of interpreting the Constitution, this thing dies an unquiet and quick death. So let's pivot quick. There's a lot going on in J6dom all of a sudden, and I want to give you guys some breaking news. I don't think you've heard much of this yet. You see a story there. Owen Shroyer put in solitary confinement. That was on October 25th. That was not as newsworthy as many people thought, because the prison in Oakdale down there in Louisiana has a policy of placing new arrivals in quarantine for 7 days while they assess their COVID status. Oakdale has a reason to be wary of COVID. It was the first federal penal institution to lose people to death as a result of COVID in the early days of the pandemic. Owen was released after his initial confinement in solitary. And I got a phone call from him yesterday, and we talked briefly. He was fine. He was aware that his phone calls were being monitored. And he was in the general population yesterday. Maybe had been since late the day before. It was unclear. I didn't ask. I did get a phone call last night, though, late last night. He's been placed back in solitary. And it's not because of COVID. The suspicion is that Owen has been placed back in solitary confinement because among the phone calls he made was one to people at InfoWars, where he may have been broadcast online. And there's a suspicion that Owen has been placed in solitary confinement because he spoke out while incarcerated. The DOJ, the Department of Justice, has supervisory responsibility over the Bureau of Prisons, and the DOJ is up to a lot right now with respect to January 6 defendants. Jake Lang was placed in solitary confinement this week, or maybe late last week as well. Jake is a pretrial detainee. He is facing charges in the District of Columbia related to January 6, including charges that he used violence, force against officers in the riot that day. Now at trial, and I represent Jake, so I know a little bit about this case. I'm co-counsel with Steve Metcalf out of New York. Steve is lead counsel. I'm just along for shits and giggles, apparently. Metcalf and I intend to place self-defense or defense of others before the jury in the Lang trial and say that while he did use force against officers, he used force against officers who were engaged in unreasonable conduct themselves. And Jake sought to defend third parties. So Jake's lawyer, Metcalf, at trial filed a motion to dismiss one of the charges against Jake. Now, this was a charge arising under 18 United States Code Section 1512, which makes it unlawful to obstruct an official proceeding. And this is a statute passed in the wake of the Sarbanes-Oxley litigation, the Enron litigation. And it's intended, the legislation is, to close a loophole against people who try to destroy documents or intimidate witnesses who are appearing in an adjudicatory context. The J6 case is the first occasion in which the 1512 statute has been applied broadly to every or almost any class of unlawful conduct. So Mr. Lang and others filed motions to dismiss the 1512 counts against them at the trial level, and those motions were granted. The government then sought an interlocutory appeal, an intermediate appeal, to get those dismissals reversed. And in a 2-1 decision, the DC Court of Appeals did reverse those decisions. We asked on behalf of Mr. Lang for the United States Supreme Court to reconsider that issue, to take a look at the appellate court decision and reverse it, basically uphold the district court. Yesterday or Monday, the DOJ filed its response to our petition in the Supreme Court, and they skewered Lang. And social media is ripe with comments about that now. Lang was violent, Lang was this, and the Justice Department, Roger Parloff says he's a follower of the J6 trials, a lawyer who Twitters about it a lot, or tweets or X's or whatever the word is now. They were wise to single out his horrible conduct and say that it's premature for the court to hear this issue. We need a trial. And I got a call from Newsweek already this morning, or an email, that I have a comment on the Justice Department's view that interlocutory appeal was inappropriate in this case. And let me read you what I sent to Newsweek, because I'll be curious if they use it. Here's a pro tip to those of you who are getting your feet wet and dealing with the press. Say as little as possible. Require them to use what you say. So Newsweek asks, do I have any comment on the DOJ's argument the case should not be brought to the Supreme Court, saying that contention does not warrant further review, particularly given the interlocutory posture of these cases? Do I have a comment? Damn right I do. Quote, that's a particularly stupid comment coming from the Department of Justice. It sought interlocutory review in the first place, end quote. We'll see if Newsweek uses it. But here's the deal. Jake's been placed in solitary confinement. He's been very outspoken. He's got tens of thousands of social media followers. He's raised hundreds of thousands of dollars on Give, Send, Go. He's written a book about all this, and he's got plenty to say about J6 and the prosecutor. He's placed in solitary. Owen's placed in solitary. And then they're playing games with the Proud Boys. The Proud Boys, have been sentenced. Their appeals are pending. We're in the process of working on their briefs now. And the Proud Boys, on several occasions, have been loaded up into buses being prepared to be moved from one institution to another, only to be taken off the bus and placed back in the facility. And this happened again yesterday. So what's going on? And here's what I think is going on. I have it from a reliable source that the district attorney in Washington, D.C. Has his thumb on these cases, that the Bureau of Prisons was prepared to classify the Proud Boys as low security risks, and that the district attorney in D.C. Objected and demanded that they be placed in intermediate or medium security facilities where there'd be more restrictions on their liberty. Here's a question I would like Congress to put to the Department of Justice, and I would like Matthew Graves, the district attorney for the District of Columbia, subpoenaed to Congress and asked point blank, Mr. Graves, did you personally insist that the Proud Boys be classified as something more than low security risks? If so, why? Mr. Graves, did you personally insist that Jake Lang be placed in solitary confinement? This man presumed innocent in a pretrial custodial situation. If so, why? Mr. Graves, did you personally have a role in the Bureau of Prisons' decision to put Owen Shroyer back into solitary confinement when he raised public concerns about the manner in which your office was prosecuting these cases? I don't know what the answer to those questions are, but I have reasons for asking those questions. Graves can deny it, and it may be true, but I have my doubts that a denial would be true, and I'm asking Congress to get involved. The new Speaker of the House, Mike Johnson, is from Louisiana. His district is the district in which the Oakdale Federal Correctional Institution is located. That's where Owen is. Representative Johnson, please send a staff member to the Oakdale facility today and ask the warden there what's going on. Why was Owen Shroyer returned to solitary confinement? I got a call from Colorado yesterday, and unfortunately, I can only remember the staff member's name. I don't remember the congressman's name. That congressman was asking questions about why Jake Lang was in solitary confinement. So, and we had a long discussion about it. I don't know what the congressman will do. But Congress is watching, and the American people are watching. And it seems to me that there are, and these are just three cases. These happen to be three cases of people involved in the January 6th riot that I know about because I've represented them, or through individuals in the Proud Boys, Jake Lang and Owen Shroyer. And what are the odds that these are the only people that are suffering as a result of the DOJ overreach, or as a result of a use of discretion to give them more punishment than is warranted because they engaged in protected political speech that the administration disapproves of? So if you're listening to this and you have any ability to influence congressmen or influence social media, spread the word. We want Congress to ask what the Department of Justice is doing to J6 defendants, both pretrial detainees and those convicted of crimes. We disagree with jury conclusions in the Proud Boys case. We'll take an appeal. We think Judge Timothy J. Kelly got it wrong in considering Owen's protected speech as relevant offense conduct and sentencing him for trespass. We'll take that to an appellate court because he got it wrong. We think Jake Lang had a self-defense claim that we'll present to a jury. We'll see what the jury does. Fine. These are matters that should be worked out in courtrooms. But if there is some behind-the-scenes hanky-panky going on, and we've got senior Justice Department officials with their thumbs on the scale using their supervisory authority over the Bureau of Prisons to make the conditions of confinement more harsh for these men, the American people need to know about it. Congress needs to react, and we need to hold these people accountable. Accountability is not a one-way street. If you're convicted of a crime, you do your time. But you don't do your time with the moral or functional equivalent of the warden in Cool Hand Luke saying, the problem is a failure to communicate, and insisting on harsher conditions of confinement because these Justice Department officials disagree with how these individuals comport themselves or with their political opinions.
And that's a great last note there, Norm. I want to make sure. So Jake Lang has not gone to trial for the charges against him in connection with January 6, 2021. Owen, however, presented himself for incarceration following a conviction for a probation violation.
A guilty plea. No, it wasn't a probation violation even. No, it was for a trespass charge.
That's right. Sorry. Yes. And what I'm getting at though, Norm, is that while these two people are being treated the exact same, I would say that, Jake Lang's situation is quite distinct from that of Owen, and Owen's is particularly egregious, in my opinion, because of the nature of his stay there in prison, right? We're talking about solitary confinement on a guilty plea for trespass.
Well, yeah, and I don't want to minimize what's going on with the Proud Boys. I mean, I'm reminded of the czar. I think it might have been Nicholas. Decision to seek the death penalty for Fyodor Dostoevsky, who participated in radical left-wing politics in the 19th century. And so he was convicted, sentenced to death, and marched out into a courtyard blindfolded, and then the czar granted him clemency. Historians argue that Dostoevsky was never really marked for death. They just wanted to terrify him to send the message out. Is there some sort of hazing going on of the Proud Boys now? Yesterday wasn't the first occasion in which they were marched out of their cells, told to gather their belongings, and we're going to be taken elsewhere. Yesterday they were placed on a bus and they sat there for a while and they were brought back in their cell. Is somebody harassing them because they can? And is that really necessary? I think, Congress, if you want to use your supervisory power, use it, and find out what's going on with the Department of Justice. Ask Matt Graves to come in and ask him if he's got his thumb on the scale, and demand answers. I think it's important, obviously, for the integrity of the criminal justice system. Hey, while we're on the topic of the integrity of the criminal justice system and politics in general, I am asking everybody to consider campaign contributions to whoever Will Rollins is running against. Tell us about Will Rollins, Mike.
I saw this video circulating last week, and I think it was posted here October 25th, 2023, from Will Rollins, CA, on X. And as you can see here, he is limited who can actually reply to this. And that's because of the 5.5 million views that this video now has, his campaign video now has, he has 2,100 likes in total. And you can see the comments here were beginning to fill up like crazy, and especially the quote tweet function here, or the repost function there, basically saying that he was ratioed out of some sort of effective campaign communications, at least on the X platform. And it's no story as to why that is. He brands himself as a counterterrorism prosecutor. And in the video, and you can see here, this is his info: former counterterrorism prosecutor, Democrat running for Congress to defeat extremist Ken Calvert and flip CA 41 from red to blue in 2024. Now, it seems like the Democrat lawyer line of election campaigning this cycle is to just harp on the word extremism or extremist like crazy. Here in North Carolina, our current Attorney General, Josh Stein, uses that for his, governor campaign. Every single chance he gets, he tries to say that something is extremist or extremism or whatever it might be, whatever boogeyman, everything is extremist. Now we're seeing it from the current governor, the lame duck, Roy Cooper, and we're seeing it from anybody who is even going to replace Josh Stein as Attorney General. No different here, except Will Rollins makes a habit of saying all the wrong things with respect to sort of, that would explain that he's got any sort of grip on the national sentiment as to governance in this country. Go ahead, Norm.
I think I don't think Will Rollins really exists. I think he's an AI creation.
That's a great. I think that's probably right.
Somebody typed into Chat GPT for the following: what would a candidate who was a complete asshole look like if he decided to run on a platform that I put people away for January 6th? You'd get Will Rollins. I mean, if you look at his video, I was inspired to become a federal prosecutor because of the events of 9/11, and I decided to get involved in prosecuting domestic or counterterrorism. And now the real threat is domestic. It's domestic because we have internal extremist groups who are determined to undermine democracy by their adherence to the views expressed in conspiracy theorists. We need to do something to limit such speech, and Will Rollins, will do it. I yearn for the days when my partner and I, he's got his arm around another guy, when my partner and I can go to a family Thanksgiving dinner and argue about something and stop arguing about politics, but argue about who gets the stuffing. I get the stuffing. I mean, come on, Will. This is almost like bad humor. If you wanted to go to a stand-up comedy club and ask yourself what a right-wing loser would look like running for Congress in California, you'd get Will Rollins. People, whoever Will Rollins is running against,
right wing,
left wing. Sorry. Sorry, left wing losers. I just don't like this guy. He makes my skin crawl. I'm going to be sending $10 today to his opponent, and I'm asking each of you to send $10 to Will Rollins.
Apparently, you're sending $10 to extremist Ken Calvert and CNA 41, right? Good. And the reality is simply this, right? He is a meme of himself, but that's who he has to be unless he wants to lose his entire network and social status. He's built his entire life. Look at this young guy. He's built his entire life around the political beliefs that he holds right now. And to depart from that in any sense of reality and duty to the country and civic nationalism, any of that would require him to make a sacrifice. And guess what Will Rollins is not going to do, Norm? He's not going to make a sacrifice at all. Yeah. Right? He's going to tell you that he loves being a counterterrorism prosecutor. And then he's going to tell you at the end of the video that he's gay, and he's going to show a picture of his partner, and then he's going to tell you that he loves stuffing, right? And then you're going to take that video seriously.
Will, go back. I mean, I didn't meet you, Will, in DC, and I'm sure you sent some people to jail, and I'm sure you feel good about yourself. And I'm sure watching your video, I'm positive that your colleagues are just thrilled that you're running for Congress, because that means you're not in the office bothering them with your self-righteous, unctuous presentation of self. Will Rollins.
It's all dressing, by the way. It's not.
Will Rollins, we wish you all the safe sex in the world, which is a polite way of saying go fuck yourself. So
anything that we want to talk about here, Norm? Because we haven't been able to really track down the article this morning, but I do want to at least mention this because this has to do with, I believe, the case out of Yale that you're pursuing on behalf.
Oh yeah, so the National Organization of Women is taking aim at Saif Khan. Now, one of the great tropes, rhetorical devices used in the criminal justice system, you'll hear this from most every prosecutor in most every case. We want to hold the defendant accountable for his conduct. So the trope of accountability is a big deal. That's why we prosecute people. We want to hold them accountable. Whether incarceration, fines, or any of the sanctions that the criminal justice system can actually impose accomplishes that, that's a different question. But the rhetoric of accountability is there. Saif Khan, you will recall, is a young man who was accused of rape by one of his classmates at Yale. My office represented him at the criminal trial. He was acquitted. The jury found him not guilty. We then turned around and sued Yale and his accuser. And among the things we sued his accuser for was defamation. We let her be a John Doe in the complaint to signal to Yale that Saif took his obligations as a Yale student seriously. And Yale treats the complaining witness in a sexual assault case as a confidential person. So we signal to Yale, we're not going to put her name out there in the world at large because we want to return to Yale. These are your rules. The Connecticut Supreme Court, however, went out of its way to say in a ruling related to the Khan case that the Yale Honor Code and Yale's rules no longer applied to this woman at the time she testified against Yale in administrative proceedings because she was no longer a student. And so this raises the question, well, if she was no longer a student at that time and the Honor Code didn't limit or impose an obligation on her to be truthful, and she wasn't given sworn an oath, and she was just an individual out there in the world, why should we treat her confidentially going forward? So Saif has announced his intention to authorize me to seek to disclose her name. Well, the National Organization of Women is all wound up about that. They're saying this reflects Khan's sense of entitlement to name his accuser. Hey, ladies, I thought the Me Too movement was premised on holding those who abused women accountable. Okay. And so you've destroyed any number of people's lives by going after them and getting them canceled, prosecuted, and sometimes in prison. Here is a case where the trial failed and a woman was found to have made a false accusation against Saif Khan. And the result is that his life has been undone. He's been thrown out of Yale. His prospects in the world have been diminished. Are you saying, ladies, that false accusers should not be held accountable? If ever the door of hypocrisy slammed, on in someone's face, it's here. Now looks ridiculous. And I think Saif is contemplating litigation against now. So keep an eye on that. I'll keep you posted on that, Mike, and others as events unfold.
Well, and one thing that Mr. Khan has done that many of you have not quite yet is follow us on X. We did earn that follow, Norm. So you should follow us on X. And I think that's all we got for today. We've got some stuff tomorrow. I really want to talk about the situation out of the UK with the hockey player whose neck was sliced open on the ice. Tomorrow, the conversation is obviously around sort of what is within the game, as one might say, and what conduct is, I guess we would say, extra athletic, right? That which falls beyond the scope of expected.
Yeah, it's a shocking video. I mean, he's body checked by another player who appears to deliberately go off his feet, and his skate goes up in the air, and bam! The next thing you know, this person bleeds to death. I mean, what are the limits on force in the game? And while we're talking about games, we could talk about the outrageous allegations against the presumptive favorite to win the national championship this year. That is the sign stealing, and whether Jim Harbaugh is done out of Michigan. But we'll save the sports for tomorrow, because I want Dawn to enjoy her safe space today. I don't want to engage in the male pastime of talking about sports and finding meaning in sports, because sociologically, oh my God, I used the word, Dawn, I'm sorry, that would be a sociological phenomenon that she might not appreciate and might not feel safe over. So thanks for listening, folks. We'll be back tomorrow. But remember, find out who Will Rollins is running against. I can't remember the name, in the 41st Congressional District in California. Contribute to that man. We don't want another J6 prosecutor in power. We've had more than enough of that, and it's time for Congress to step up, step in, and look at what the hell's going on in these cases.
Now is not our women, is what
Dawn says. Dawn, speak to me, baby.
Dawn with the Tiger Woods
speak to me
for the win there. All right, and we will maybe convert some of you to listen when we do talk about sports. I know that there's some phenomenon, Norm, within the sort of populist right that really is condescending to any attention to higher athletics, and I really want to understand that. I think I have a base grip on it, but
I don't. I mean, and I'm not sympathetic to the criticism, but I do enjoy having listeners. And if people don't want to hear about sports, I guess I have to hear that. But they have to listen to me.
Who am I? I'm 3-5 in our fantasy league. So, yeah.
And I am tied for first in my division at 6-2, one of the top rated teams. And it just because it's the Law and Legitimacy League has nothing to do with my superior performance in the league.
Anyway, it's embarrassing.
Yeah, and it's totally a fluke. I worried when I picked my team that I wouldn't win a game this year, and now that I'm winning, I'm copping an attitude.
And I was the opposite. I picked my team, and I was like, man, I hope I don't. I hope I lose at least one. Here I am. I can't buy a win. Anyway,
careful what you wish for.
Dawn says talk sports. Dawn is like saying all the right things today, and not that you were saying anything wrong yesterday. I just love it. There's no bad blood here. We're all adults.
All right.
See you later.
All right. Bye.
Bye.